Hi, thanks for using my court coach. I'm Sarah. I'll be your instructor today as we talk about the judgment checklist for a dissolution or legal separation case, also known as Form FL-182. As with all our court forms, you want to fill in your identifying case caption information at the top. This is not a required form. This is an optional form. I like to use this when I'm preparing a judgment packet to submit to the court for processing because it does include a checklist of forms that you will need to include, and I just find it very helpful. I also think it's helpful to provide to the clerk so that they know what documents you're claiming to be providing to them so they can go looking for them in the packet if they're unable to immediately locate them. There are three types of judgments that this covers. One is a default with no agreement. That's where you have no response and no written agreement. The other is a default with an agreement, where the other party has not filed a response, but you have reached a written agreement. And then the third is the uncontested case, where the other side has either filed a response or made some other appearance and you do have a written agreement. So we're going to start with the default with no agreement. It is important to know with all the documents that are being provided that you do need to provide the original in 2 copies. 1 copy will come back to you, 1 copy will go to the other party unless otherwise specified. So we're going to start with the proof of service of summons. The court needs to know that there has been proper service in your case. If this has been previously filed, just mark the box that indicates that. Otherwise, make sure to include that form with this packet. You will also need the request to enter default form. That's the FL-165. And with that form, you want to include a stamped envelope addressed to the respondent with the court clerk's address as the return address. If that has been previously filed, go ahead and mark the box that indicates as such. Otherwise, be sure to include that form plus the envelope. You also need just the petitioner's declaration regarding service of disclosure. Because this is a default, we only need that from the petitioner. If that has been previously filed, go ahead and mark the box that says that. Otherwise, include that as part of your packet. We need 5 copies of the judgment form. That's the FL-180. If you have a written proposed order as part of that judgment form, then you can attach it to the judgment form. Otherwise, there will be other forms that will be helpful to the court in determining final resolution of the issues in the case. You will also need a notice of entry of judgment form. This is the form that goes back to each of you that lets you know that a judgment has been entered. Along with that, you want to include 2 stamped envelopes, 1 stamped to yourself, 1 stamped to the other party. Make sure to include proper postage for both for the court to be able to return both the judgment and the notice of entry of judgment forms to each of you. If there are minor children of the case, you may need to file an updated declaration under Uniform Child Custody Jurisdiction and Enforcement Act, that's the UCC-JEA, if there have been changes since the last form was filed. If not, you do not need to provide this. You may need to include an updated income and expense declaration if one has not been filed in the past 90 days and there have been changes since then. You have the option of including the guideline child support calculation. If you have access to the child support calculator software, then you can go ahead and include that as part of your judgment package. You do need to include, whenever child support is being addressed, your notice of rights and responsibilities. That's your form FL-192. With respect to the child support order, again, you have the option of including a proposed written order that would be attached to your judgment. You also have the option, if it's easier for you, to use some court-provided forms. You can choose between the stipulation to establish or modify child support and order. That's the FL-350 if you were able to reach an agreement, at least with respect to the issue of child support. Otherwise, you can use the child support information and order attachment form. That's the FL-342. You have the option of including the income withholding for support order. This is not mandatory. This is if you would like to have an order that allows you to garnish the wages of the obligor, you can include this form. And then finally, child custody and visitation. You can either include language in your written proposed attachment order that's going to be attached to the judgment, or you can use the form FL-341, the child custody and visitation parenting time, and you also have the option of using any of the other FL-341 forms that have very specific provisions as to custody and visitation orders. If spousal support is at issue, either it's being requested, the marriage is over 10 years in duration, or the termination of spousal support to the respondent is being requested, the court requires you to provide the spousal support spousal or partnership support declaration attachment. That's Form FL-157. And again, if there has not been an updated income and expense declaration, then you would need to include that as well. And then you will need to include the spousal, partner, or family support order attachment, FL-343, or include language addressing spousal support in your proposed written order that's attached to the judgment. If assets or debts need to be divided or assigned, you do need to include the property declaration. And again, if you have separate property, you will need to include a separate one that addresses separate property because this is a default. Your written order can include or address the property division, or you can use the FL-345 for that purpose. That's the property order attachment to judgment. If attorney fees are being requested, you do need to include the Form FL-319 that requests attorney fees. And if your attorney fees request is not addressed in the proposed written order that you're attaching to your judgment, you can use the Form FL-346 for this purpose. Default with agreement, it's pretty similar to default with no agreement. There's only a few forms that are not required. One is that property declaration, the Form FL-160. One is the spousal support declaration attachment, the Form FL-157, and then the form for the attorney fees is not required either. But otherwise, this requires all the same forms as the default with no agreement. So I'm not going to go line by line through that one, but I will do so with the uncontested case because it's a little bit different. A lot of the forms are the same, but there are some additional forms that need to be provided. So I'm going to go through those. As with the default cases, you do need your proof of service of summons. There's an additional form you need called an appearance stipulation and waivers form, FL-130, that needs to be signed by both parties, and that basically indicates that you know you have a right to a trial. You're giving up that right to trial to reach this agreement, and there will be a separate video that will specifically address that form. Because the respondent is participating in this case, his or her filing fee is required. So if it has been paid already, go ahead and mark the box that says previously filed. If it has not, then that needs to be included as part of this packet. With the declarations of disclosures, we need both the petitioner's and the respondent's preliminary declaration regarding service of declaration of disclosure on file. Again, if that's been previously filed, mark the box that indicates that. Otherwise, provide those with this packet. You also need something that addresses the final declarations of disclosure. Either you have filed those or are filing them now, so you would include them with this packet, or you're waiving them. If you're waiving them, you need to include either the stipulation and waiver of final declaration of disclosure form, that's the FL-144, or you can include written language that waives the final declaration of disclosure requirement in the proposed written agreement, your marital settlement agreement. I prefer to use the form. I think it's a little easier for the courts to locate because that is very important language that has to be there before they can process the judgment. You will need your Form FL-170 again, your declaration for default or uncontested dissolution or legal separation. You will need the written agreement of the parties, your marital settlement agreement. You're going to attach that to the judgment. Again, it's 5 copies of the judgment form, the FL-180, the notice of entry of judgment form, and then the stamped envelopes that go with that. And then the rest of the documents we've already gone over regarding the minor children. It's just a repeat of the same documents. So these are all the documents you will need to submit as part of your uncontested case judgment packet. So I hope you found this helpful. Good luck.